The Danish Data Protection Authority, Datatilsynet, has imposed a ban on the use of Google Chromebooks and Google Workspace in primary schools in Helsingor Municipality, citing non-compliance with the General Data Protection Regulation, GDPR. This decision is rooted in the fundamental principles and requirements of the GDPR, particularly those related to lawful processing, transparency, accountability, and data controllers' responsibilities. The ban was influenced by the Court of Justice of the European Union's (CJEU) judgment in Schrems II, which emphasizes the need for strict requirements to be met when transferring personal data to third countries outside of the European Economic Area (EEA). The European Data Protection Board's (EDPB) recommendations on measures to supplement transfer tools, adopted on November 10, 2020, were also considered in this decision. The new Standard Contractual Clauses (SCCs) for data transfers, which supplement existing safeguards, are now the applicable requirements. The Schrems II case and subsequent regulatory attempts have reshaped the legal landscape for cross-border transfers of personal data. The emphasis on supplementary measures, risk assessments, and the need for a case-by-case evaluation of third-country laws and practices underscore the importance of ensuring adequate protection of personal data under essentially equivalent European standards. This has significant implications for organizations operating internationally, necessitating careful consideration of data protection safeguards and the implementation of robust supplementary measures to maintain GDPR compliance. The EDPB suggests a six-step approach, which includes a more detailed explanation of supplementary measures, such as pseudonymization and encryption, as well as specific use cases demonstrating effective supplementary measures. The Danish Data Protection Authority, DPA, suspended personal data transfers to the US by Helsingor Municipality, which used Google Chromebooks and Workspace in schools. This decision was based on concerns about the effectiveness of standard contractual clauses, SCCs, in ensuring data protection. The municipality had implemented SCCs as a transfer basis and conducted a transfer impact assessment, TIA, following DPA and European Data Protection Board, EDPB, recommendations. The TIA assessed the risk of U.S. authorities accessing personal data, concluding a 50% probability. However, it also revealed that personal data transferred to Google LLC in the US would be available in plain text, despite encryption and pseudonymization. Google personnel could access the municipality's personal data, as they held the decryption key. This meant that the municipality had no complete control over the access of personal data in the EU data center. The TIA noted that Google LLC may qualify as an electronic communications service provider under Section 702 FISA. However, the municipality argued that the data accessible to Google LLC was excluded from access under Section 702 FISA, as it was not transmitted by but to Google for support services. Additionally, the municipality's personal data did not comprise data about U.S. persons, and U.S. authorities were thus barred from accessing data under Section 702 FISA. Despite the municipality's risk assessment, the Danish DPA found that the risk to the rights and freedoms of the registered pupils was too high, and the processing did not comply with the GDPR requirements. The DPA criticized the municipality's data processing practices, including the transfer of data to third countries for technical support without adequate security and protection. The DPA decided to ban such processing for violating the GDPR and suspended any related data transfers to the US until it was brought in line with the GDPR. The main risk identified was processing personal data for other purposes, despite Google's role as a processor and the data processing agreement signed with the municipality. The Danish Data Protection Authority, Datatilsynet, has imposed a ban on the use of Google Workspace in Helsingor Municipality, citing violations of the General Data Protection Regulation, GDPR. The decision is based on a risk assessment highlighting concerns regarding Google's potential to breach contractual obligations, use personal data for unintended purposes, and transfer data to third countries, particularly the US, where problematic legislation could compromise data subjects' rights and freedoms. The risk assessment also identified insufficient encryption measures, inadequate testing of hardware and software, and lack of documentation on controlling Google's access to personal data. The municipality failed to mitigate these risks, leading to the ban on Google Chromebooks and Workspace. The Danish DPA emphasized the importance of thorough risk assessments and robust safeguards for compliance with Chapter 5 of the GDPR, particularly in cross-border data transfers and protection of sensitive personal data. The Danish DPA believes Google acts as an independent data controller, processing personal data for its own purposes, contrary to the municipality's assessment. The authority identified areas of concern, including unauthorized disclosure and transfer of personal data to third countries, and emphasized the need for municipalities to conduct transfer impact assessments, TIAs, to demonstrate that transfers are not subject to problematic legislation. Investing in risk assessment software tools and following the privacy by design and by default approach can help mitigate practical challenges. Technical measures, such as full encryption, pseudonymization, and split processing, are considered the most effective supplementary measures to ensure personal data security, particularly when using cloud computing services. Municipalities are expected to take relevant actions, develop strategies to manage legal risks, and implement measures to protect personal data in accordance with the law. In the context of overcoming data protection limitations and ensuring secure data analysis, one approach is to employ technical solutions such as multi-party homomorphic encryption. This method combines secure multi-party computation, allowing for the querying and analysis of encrypted data without the need for decryption. This approach would enable municipalities to scale and effectively protect data, providing a more robust alternative to current data protection measures. Another emerging technology-driven solution involves storing data in the end-user's personal cloud, following the user-held data model. This approach grants individuals greater control over their data and significantly reduces the need for unnecessary open-ended cross-border data transfers. Users could choose their geographic location and keep their data stored locally within the EEA in a more decentralized manner, thereby enhancing data privacy and compliance with legal frameworks. The research for this paper was supported by a Novo Nordisk Foundation grant for a scientifically independent collaborative research program in biomedical innovation law. The paper cites various sources, including a full account of homomorphic encryption, supplementary measures and appropriate safeguards for international transfers of personal data after Schrems II, and the future of international data transfers with a user-held data model. These sources provide further insights into the technical and legal aspects of data protection and privacy, highlighting the complexities and challenges involved in ensuring compliance with data protection laws while facilitating data analysis and sharing. The paper concludes by emphasizing the importance of exploring novel solutions to address these challenges, particularly in the context of international data transfers and privacy-preserving data analysis. It underscores the potential of homomorphic encryption and user-held data models to enhance data protection and compliance with legal frameworks, while also enabling effective data utilization for various purposes.